Jay. Welcome to Mvskoke Radio, your weekly source for tribal and community news, interesting guests and discussions, plus a local events calendar. It's Jay Stone Go, Gary 5 Jahu Jifkados, Mvskoke Radio, Mabo Hedgeta Wedgkis. We hope that everyone is enjoying our little break in the weather. Nice cloudy day here in Okmulgee. We got a couple things we'll be sharing with you this morning. First of all, a nonprofit agency for the Running Strong of American Indian Youth delivered 44,200 pounds of stable shelf food to the Pine Ridge Reservation to help out with their battle against the effects of the COVID-19 virus. So we'll be talking with Dave Lonelk, who's one of the staff members there. In the second half of our show, we're going to be sharing the recording of the discussions at the U.S. Supreme Court regarding the McGirt case. That's one where we're talking about the jurisdiction of the Mvskoke Creek Nation and being opposed, as they will, by the state of Oklahoma. The whole thing is an hour and a half, but I whittled it down to some highlights. So about a half an hour, a little over half an hour, you'll get to hear some of the main primary arguments in this particular case. But first of all, let's get on with our program here. Mr. Lonelk, are you with us, sir?
Yes, I am.
Okay, now where are you right now?
I am at my office, the Running Strong field office in Pine Ridge, South Dakota.
Wow, Oglala Lakota.
Yes.
We have some interesting news about your organization, Running Strong for American Indian Youth, making this wonderful donation of goods to the Lakota people on the Pine Ridge Reservation. And it's just so... we're getting some interference, I believe.
Oh, okay.
Okay. Anyway, we'll press on anyway, static and all. Now, first of all, for folks who are not familiar with your organization, what is Running Strong for American Indian Youth?
Well, first off, Gary, I want to say, we'll start off with the traditional Lakota greeting for the people. I want to say, Hihani Washte, Mtakiapi, Dave Lonelk, Imachiapalo, Oglala Lakota tribe, and Mata. That's good morning to the people. My name is David Lonelk, and I hail from the Oglala Lakota tribe. I am currently the field coordinator for Running Strong for American Indian Youth on the reservation of the Oglala Lakota tribe. Excuse me. And what our mission statement is to help the American Indian people meet our immediate survival needs of food, water, and shelter while implementing and supporting programs designed to create opportunities for self-sufficiency and self-esteem. And so we originally started back in 1986. Of course, this was right when I was like a baby.
Don't we all remember those days?
Yes. But yeah, well, our mission here on the Oglala Lakota tribe is to provide, especially for during this COVID-19 global pandemic, food boxes, because that's been a huge issue, as I'm sure it is everywhere, especially within the reservation, food shortage. And so we provided, Running Strong for American Indian Youth, we have provided 22 tons of food. Now that equals 1,700 dry food boxes. Because I don't have a huge walk-in freezer, we would normally do frozen food boxes. But ever since the pandemic hit, we've been scrambling to figure out the best way and the safest way to get food to the people. And, I've just been following CDC as well as our own tribal regulation guidelines as to how to handle the acceptance of outside donations. And so when we received the shipment, our shipment was disinfected by our Oglala Sioux Tribe Emergency Management Program, and then it sat over the weekend, which is why I kind of required the dry food box instead of the frozen food box, so that way it wouldn't thaw out, and I wouldn't be giving thawed out meat and things to the communities. And so after it sat, I distributed it to my districts. We have 9 districts on the Oglala Sioux Tribe, and then within each district, they had their own safe method of distribution to their communities. And within my community of the Porcupine District, I did a no-contact kind of drive-through style curb, what is it called? Curbside pickup, as you would put it. So, of course, we had gloves, masks, hand sanitizer, and the contact with the people was minimum, and we got them food boxes safely and within a quick time.
Take a second for me and fill us in on what your organization is. The title, Running Strong for American Indian Youth, is pretty intriguing. So is it like an athletic support kind of organization?
Well, we do. Okay, so overall, the Running Strong for American Indian Youth was co-founded with Billy Mills, the gold medalist, and Eugene Krizek back in 1986. And this was following Billy wanting to get with Joe American Horse, who was the tribal chairman at the time, excuse me, was trying to get running water wells drilled for the people of the Oglala Sioux Tribe. And so Billy Mills and Eugene Krizek came up with the, co-founded Running Strong. So as we all know, Billy Mills won the 10,000 meter back in 1964 in Tokyo. And so that's where the Running Strong comes from. And, he wanted to help the, American Indian youth.
Right. Mr. Mills is quite a gentleman. I've had the occasion to chat with him a few times, and he certainly makes us proud. And I've seen the film of his race and the final outcome where he was victorious. Now, being member of the Oglala Sioux Tribe and delivering this food to that reservation, first of all, there's got to be a lot of self-satisfaction in delivering this kind of help to people who need it.
Yes. I actually do take a lot of satisfaction, and actually more than that, pride. Being able to be a beacon of hope, so to speak, with our people of the reservation. We have various other programs that we do that work out of our field office here. So we've kind of become known as the go-to program. I don't step on any of the other programs' toes. As a matter of fact, I work with them and how we can get our needs of the people met as quickly and as safely as possible. On top of food and in-kind distribution, we also do water connections and, in the wintertime, a heat match program. And so, like I said, we're a pillar of light for those who are, in their darkest moments. And that's kind of the self-satisfaction, I guess, I take from that is I'm able to help those people who are usually never helped or overlooked.
I think you hit the nail right on the head there. And what I'm interested in also is how this came about. Could you maybe describe the situation there because of this need now or its status, perhaps?
Okay. Well, I want to say I started working with Running Strong for 11 years now. But before that, my father was the field coordinator, so I kind of, throughout high school and, those years, I did a lot of volunteer work. And so growing, I was kind of like, maybe I grew up into this role, I guess. I've seen the needs of the people, and, my father, Ken Lonauk, was the original field coordinator. He kind of set that example for me, so I had some huge shoes to fill. And growing up through high school, I've seen the families. I've seen the families that needed things like handicap ramps, winterizing or weatherizing homes for winter, heat match, families that just needed water wells and septic systems. And so, over the years, my dad is he grew old, and he still volunteers his time, and he hangs around up here in our office. But throughout those years, we've kind of like toned things down and dialed things back. And so when I was hired on, I wanted to see a need. I seen a need, and I wanted to fill a need, and that's just kind of how I went from there. For me, back then, was hungry children, and so back in 2009, that's where I started. Where I started my journey from with Running Strong was feeding the children. From there, we reached out to the community. And a lot of everything that we do was community input. What would you like to see? What's something that you would need? What's your needs? And it grew from there, Gary. It grew from there. It became winter coats. A lot of children need winter coats. What else? So we did winter kits, stocking caps, mittens, scarves, snow boots. We do snow boots now. And everything that we do now, all the services that we provide are all based off of community input. Things like the dental hygiene kits for children, because I think that's something that's really important is children's teeth. And so we do the Smile Strong dental kits, and that is toothbrushes, toothpaste, dental flossers. We have a timer for whenever the children need to brush their teeth. It's kind of like a little hourglass. But every service that we do provide right now is based off of community input, and like I said, you see a need, you fill a need.
Let me ask you this. Unfortunately, that Pine Ridge is often a target of mass media, major media outlets going to do stories about the poverty facing Native American people. And I don't know, you feel picked on, I guess, maybe. But what are your thoughts there? And secondly, have you had any feedback from the recipients of this support?
Okay. Well, I know that the media does target our reservation, specifically, based off of the poverty. But I don't see us as for the way Running Strong, the way we handle that kind of situation. I don't like to focus on any of the negativity or any of the, poverty. That's I don't do that. I don't try to make that my focal point.
What about feedback from people who have received this help?
Oh, okay. For one thing, when we do these, of course, we're a nonprofit. We raise the funds. And by the way, I want to take this opportunity to thank all our donors who may be tuned into this broadcast, this show. They're the ones who really, in their heart, want to give to this organization, and in turn, we turn around and we be able to provide these services. That being said, when the community does come here, and I do ask for feedback, I've heard, again, for me, nothing but wonderful things, especially when the heat match time rolls around, and we're in South Dakota. It can drop to negative 20 below zero, and so when I do the heat match, that keeps somebody's lights on, or that puts 50 gallons of propane in their propane tank. It's the same for the water and the food boxes and all the in-kind that we do distribute. Again, like I said, I don't like to focus on any of the negative or the poverty of it. Like I said, I'm just seeing a need and filling a need. Well,
I think we need to give credit to the Oglala people for surviving through the American occupation as some people would call it, and then the harsh economic conditions that face you folks. Now, where do you go from here? This is an incredible program, 22 tons of food. What's next?
Well, at this point, we're trudging forward with our water connection program. As for the foreseeable future of food and in-kind, that remains to be seen. I do know the reason why I'm saying this is because I work heavily with the Oglala Sioux Tribe emergency management program to figure out how best to implement this food shortage, or this, the food emergency food distribution. And so, talking to them will kind of set up the next thing that we should be planning in terms of food distribution.
Okay. Do you have any more projects like this coming up in the near future?
Which ones? The food distribution?
Food, the clothing. You mentioned heat. I presume that'll be for colder weather, but we've got the end of spring and the coming of summer. Anything happening during those hotter months?
More or less just food distribution. And like I said, during the hotter months, we're focusing on getting our families' water connections. So, especially now, during this global pandemic, they're saying the main thing to keep safe is to keep washing hands.
Right.
But it's kind of hard to do that when you're a family of 4 or 6, and you have no running water. So our main focal point throughout the summer will be trying to, getting running water to families in need.
Okay. Dave, now, if someone was interested in supporting your program or wanted more information about what you do, how do they get in touch with you?
Well, they can call me at my field office one of two ways. It would be 1-605-455-2975, and we can go about that route. Or the most easiest way, everybody has smartphones and, the internet is so readily available. The other way that they could, kind of find out more about us, and maybe if they feel like they want to give a gift, that way would be www.indianyouth.org.
All right. Well, Dave Lonak, thank you so much. We appreciate you taking time. I know you're busy, but we want to say Lila Washtay, and we'll get out of your way here.
Aho, thank you, Gary. I want to thank you for the opportunity, for letting me, speak my piece, and letting the people of your fine show know what it's like out here. And it's scary everywhere right now. But I think as long as we all stay together, pray together, I'm sure that we'll all come out on top of this. Okay.
Well, Dave, Inga, we appreciate it, and good luck with it. We'll keep our eye out and kind of watch how you're doing there. Okay, Mado Chooch. Okay, Dave Lone Elk with Running Strong for America. We're going to take a short little pause here, and then we'll be back with some of the highlights of the discussion of the McGirt case before the United States Supreme Court. Please stay with us here on Mvskoke Radio here on The Brew.
Who am I? Am I native? I don't want people assuming things because I'm Indian. I just want to be me. But how do I live in two worlds? Some guys just check out by doing meth. But that ain't for me. Because I see my family, my friends, my drum making, my future. There are a lot of cool things about being who I am. And meth isn't one of them.
Learn more at ncai.org. A message from the Partnership for a Drug-Free America and the National Congress of American Indians.
Welcome back to Mvskoke Radio here on The Brew. Back on May 11th, the case that we've been watching and waiting for was McGirt versus Oklahoma. The concerned citizens were wanting to know whether or not, I guess, Oklahoma has still possessed a reservation status under the Mvskoke Creek Nation, and that was the argument being brought before the justices. Now, we know that it's far, far more complicated than that, but what we've done here is go through the entire more than hour and a half and lift some of the, I guess if you might call them highlights, some of the more strong points that were brought up. So you'll be hearing representatives who are with the tribe making those arguments, and then some for the state of Oklahoma. Plus, in between, you'll hear the questions, some of the questions from the United States Supreme Court justices. So here we go. We've got some excerpts now from the McGirt trial before the United States Supreme Court.
You'll hear argument first this morning in case 1895-26, McGirt versus Oklahoma. Mr. Gershengorn?
Mr. Chief Justice, and may it please the Court, this case is resolved by the fundamental propositions that decisions about sovereign rights are for Congress to make, and Congress makes those decisions by speaking clearly in the text. The decision below must be reversed because the text makes clear that Congress never terminated the Creek Reservation and never transferred federal criminal jurisdiction to Oklahoma. I have 4 basic points to make this morning. First, the Creek Nation had a reservation. The relevant treaties reserved the lands from sale and solemnly guaranteed the lands for the Creek to govern. The text of both treaties and statutes expressly identified the Creek land as a reservation. Nothing more was needed. Second, Congress did not disestablish that reservation. Indeed, Congress considered hallmark language of disestablishment and rejected it. Congress initially sought cession, yet instead provided only for allotment. Then, when congressional inaction would have dissolved the tribe, Congress instead preserved the tribe and its government for all purposes authorized by law, and it did so against the backdrop of existing tribal authority to legislate over reservation land. Those congressional judgments should be respected. Third, Congress did not transfer criminal jurisdiction to Oklahoma. At statehood, the Major Crimes Act established exclusive federal jurisdiction over enumerated crimes in, quote, any state of the United States. When Congress overrides the Major Crimes Act and transfers jurisdiction to a state, it does so expressly, and it did not do so here. Finally, Oklahoma's rhetoric about disruption does not change the result. On the criminal side, this court's decision in Ramos is a complete answer, and on the civil side, the main issues are tax and other regulatory issues that are routinely resolved by tribal-state agreements. In any event, Parker makes clear that questions of sovereignty are distinct from claims of reservation status. This court should resolve the reservation question, leaving jurisdictional disputes to Congress, the relevant sovereigns, and then for this court to resolve if and when they arise.
Counsel, the state argues that the territory should be analyzed as a dependent Indian community under 1151 and not as a reservation. They base this argument on our decisions in Sandoval and Creek Nation and 1151 itself, and the fact that the Creeks have always maintained, they've been adamant about the fact that they are not reservation Indians. Now, you refer, of course, to the many times in which the treaty is referred to as a reservation, but what is your answer to the state's analysis of our precedent?
So, Your Honor, I think both the precedent and the language support the idea that this is not a dependent Indian community. What this court said in Venati and what then Judge Gorsuch said in Hydro Resources is that the dependent Indian community label is a catch-all for tribes that did not have a reservation and are not on restricted lands. The best evidence of what Congress thought about whether Creek lands were a reservation under the statute is that Congress referred to those lands as a reservation under the statute. With respect to Sandoval and the other cases, it is crystal clear that when Sandoval and those cases are using the term dependent Indian community, and that they are describing tribes and other groups that are within Congress's broad power to legislate for tribes broadly. They are not excluding the Creek. Indeed, and
thank you, Counsel. Justice Thomas?
Yes, Counsel. In Solemn and in Parker, those cases only involved the disposition of surplus land. And here, of course, there's much, much more being done in a whole series of statutes involving both sovereignty and the allotment of land. Can you point to any case in which we've applied the solemn fact framework to a case that does as much as is being done in this case?
So, Your Honor, I think the key point on the key point on the Parker-Solemn analysis is, as Your Honor pointed out in that opinion, that those are not that analysis doesn't derive from anything special about how much work Congress is doing. The reason the court has always required plain text is because treaty rights are at issue and plain text is required to abrogate treaty rights, and because sovereign rights are at issue and plain text is required to abrogate sovereign rights. So there's nothing magic about Parker and Solemn in terms of whether they're dealing with surplus lands or not. The key point in Parker and Solemn is that plain text is required to do the kinds of transfers that are at issue here. And when you look at the plain text, I think this case is even stronger than Your Honor's opinion in Parker for three main reasons. First, of course, is that the tribe was not absent from the land in the same way that the tribe was in Parker. Second, the land here was allotted almost entirely to the tribal members themselves, to Indians. And third, Congress took steps in 1906 to preserve the tribe. And I guess the thing I would point to, Your Honor, when you ask about whether there are cases like this, I think this is stronger than other cases.
One of the arguments, I think, is that whether they're a reservation or not, Congress wanted state courts to try the major state crimes. And in reference to that, I think the government cites Felix Cohen, who was a great expert in this area. And I looked at his letter. He does seem to say that. So if you have any comments about that, about his argument or about that particular aspect of it, I'd like to hear them.
So, Your Honor, I think that the law is clear that Congress did not intend for tribal crimes to be tried, and I think this is one of the most straightforward statutory construction cases this court will see. The Major Crimes Act at statehood provided that it applied to any state of the United States. There is no exception for Oklahoma, and there was none before, at, or after statehood. Second, what they have pointed to, what the other side has pointed to, is what happened before statehood. And what happened before statehood was that crimes were being prosecuted in the name of the United States in courts set up by Congress, applying federal law, which had adopted Arkansas law as the rule of decision. It is the exact opposite of conferring jurisdiction on the states to try. Third, there was nothing in the Enabling Act that would have changed that. Indeed, the Enabling Act sent to federal courts all cases which, had they been committed in a state, would have been subject to federal prosecution. That describes the Major Crimes Act perfectly. And finally, Your Honor, when Congress transfers jurisdiction to a state, it does so expressly. In the Gauntlet, which this court described as the first major transfer of jurisdiction, the language used was jurisdiction is conferred. In Public Law 280, the states shall have jurisdiction. In New York shall have jurisdiction. And even with respect to Oklahoma, in 1908, when Congress transferred probate jurisdiction, it said that the Oklahoma courts shall have jurisdiction. And so,
thank you, Counsel. Justice Alito?
You referred to the Oklahoma Enabling Act, but the language in that is that a case would be a case that was pending in the territorial.
Justice Kavanaugh?
Thank you, Chief, and good morning, Mr. Gershengorn. I want to talk a bit about the history and maybe make a comment, and you and your colleagues can react. But this is not a situation where there's a reservation in an existing state, and Congress has arguably diminished a reservation. This is a case with a territory that by 1890, Indian Territory was predominantly white, about 60% of the population, also a significant black population, about 10%, and about 30% Indian. And the question, as of 1890, how did we get there to that situation? You go back to the treaties of 1832 and 1833 that grant the Creeks and the five tribes land. But then the Civil War is key. And the five tribes all align with the Confederacy in the Civil War. The tribes have black slaves. lots of black slaves. And then there's a new treaty in 1866 because the United States is not happy that the tribes have aligned with the Confederacy. Why does that matter for us? Because in that new treaty in 1866, it grants rights of way to railroads. The railroads lead to settlements. The settlements lead to new towns that are predominantly white. So by 1890, you have an odd situation of an Indian territory nominally that's predominantly white. So Congress's options at that time are to remove the whites, to remove the Indians. Neither of those was going to happen. So the other remaining options were tribal government over non-Indians, which of course is contrary to tradition, or to create a new state. And Congress chose the new state option, it seems, and then had a lot of things that happened over the next 17 years. So I just wanted to get that history out there because I think we're talking about Indian territory and reservations when in fact it was 60% white, 10% black, 30% Indian in the relevant territory.
Counsel, you have time for a very brief comment.
So I'll just say very briefly, Your Honor, after statehood, the 85% of the Indian territory remained in Indian hands, immune from taxation. The idea that statehood and reservation status are inconsistent is refuted by the fact that Tennessee was 75% reservation at statehood. At statehood in South Dakota, it was 47% reservation. I think Your Honor's sense of the history and the incompatibility of reservations with statehood is not historically accurate.
Mr. Kanji?
Thank you, Mr. Chief Justice, and may it please the Court. I would like to go straight to Justice Thomas's question about the governing framework here and make 3 points. First, there is nothing radical about the Parker-Solemn framework. It hews to ordinary principles of statutory construction and fundamental principles regarding the separation of powers. The state can't win under that test, and hence it is advocated various amorphous alternatives. I think, Justice Thomas, nothing about the fact that there was a series of statutes here changes the fundamental principles that should apply. There are, to answer your question directly, other cases that have involved a series of statutes. The Matz case involved a tremendous amount about the history of California, a series of statutes and executive orders over time. Solemn involved the creation of a reservation only 8 months before statehood. Every state likes to claim that its history is exceptional, but there's nothing about Oklahoma here that should cause a divergence from this court's test. And
Thank you, counsel. I'd like to return to Justice Alito's question. Congress passed legislation at the turn of the prior century saying that the United States laws and the laws of Arkansas, which would be applied in Oklahoma, would apply to all persons therein, irrespective of race. Now, if you prevail, the laws in the eastern half of Oklahoma will be different. The applicable law will be different dependent upon race. So how is that consistent with Congress's legislation?
Thank you, Mr. Chief Justice. It's a critical question. What the 1897 statute did was to apply federal law irrespective of race. The territorial law and Arkansas law as assimilated. There was nothing radical about that. Under the General Crimes Act and the Assimilative Crimes Act, state law was often applied where federal law did not exist. But then what happens, of course, is this watershed moment of statehood. And statehood always changes the status quo. And when it comes to Indians, what it does typically is reserves federal power over the Indians while, of course, giving state power over non-Indians to the states. And there's nothing in the Enabling Act or the Five Tribes Act that suggests that that status quo, the normal way of dealing with it, was supposed to be departed.
All of it, we're told that there are many state tribal cooperative agreements, but if the state lacks authority to apply its own law, what becomes of all those state tribe cooperative agreements?
The agreements, Your Honor, will remain in full force and effect, and this is critical. If we prevail, state law does not evaporate in the reservation. Under this court's doctrines, state law applies in many situations with respect to, especially with respect to the non-Indians in the area, and that's what leads to these cooperative agreements. Reservations involve the different jurisdictions all having authority, and that has been the premise of shared jurisdiction has underpinned these cooperative agreements. And the best thing I can point you to is not my words, but the words of Congressman Cole's brief. And that's a remarkable brief. I think very few briefs like that have been filed in this court in the area of state-tribal relations, where you have senior members of Congress, former governors, former state legislators saying, please do not disestablish this reservation, because the exercise of tribal sovereignty in cooperation with the state has underpinned these agreements. And the authors of that brief were the authors of many of the agreements on the state side, and it's this premise of shared jurisdiction that has allowed for shared governance in Oklahoma to the benefit of all citizens there.
Justice Sotomayor?
Counsel, could you finish your answer to Justice Breyer, please?
Absolutely, Justice Sotomayor. The cases that would have been cognizable in federal court if Oklahoma had been a state included prosecutions under the Major Crimes Act or the General Crimes Act. The Enabling Act is very clearly saying that those are to be transferred to federal court. As to the practice, this is critical. Nationwide, around the nation, states were arrogating criminal jurisdiction to themselves, and the federal government was abdicating it, even in cases where the reservations clearly remained intact. That happened in South Dakota, the Solon case. That happened in Nebraska, the Parker case. That happened in Washington State, the Seymour case. That happened in Mississippi, the United States v. John case. In all four of those cases, this court unanimously, across different eras, different compositions of this court, paid no heed to that practice. For this fundamental reason, the acts of executive branch officials cannot subvert the will of Congress. Those acts of executive branch officials do not run the gauntlet of bicameralism and presentment. And here, there's all the more reason not to pay those heed. We know that federal officials were subverting the will of Congress in Oklahoma. After statehood, they would not allow the Creek Nation to hold elections for its chief, its national council, even though the Five Tribes Act clearly preserved those powers. So why we should pay heed to the acts of federal officials when they were clearly acting illegally is something that the state has never explained.
Justice Alito?
Am I correct that more than 90% of people who live in the area directly affected by this case are not members of the Creek tribe?
That is correct, Your Honor.
Well, what would you say to those people if we decide this case in your favor? Won't they be surprised to learn that they are living on a reservation and that they are now subject to laws imposed by a body that is not accountable to them in any way?
There are a number of responses, Your Honor. First, very little will change for them. Certainly, very little to the bad will change for them. They will largely remain subject to state law. They will benefit in significant ways from reservation status. Justice Breyer asked a question at the last argument about the Tulsa businessman. Well, that businessman could wake up the day after the argument and qualify for enterprise grants that attach to reservation status.
What will be the extent of the tribe's authority over these non-Indians? For example, if any member of the tribe has a contract dispute with a non-member, say it's about an employment contract or a lease or the purchase of goods, will the tribal member be able to sue the non-Indian in tribal court under tribal law?
No, Your Honor. Assuming that this takes place on fee lands, which is, as you've noted, the majority of lands in the reservation, under this court's precedents, it's clear that absent affirmative consent, no, that case would proceed in state court. The tribal law presumptively would not apply to non-Indians with respect to activities taking place on fee land.
General Mansinghani?
Thank you, Mr. Chief Justice, and may it please the court. Oklahoma has jurisdiction over the eastern half of the state because it never was reservation land and is certainly not reservation land today. To start, the land was not public land reserved from sale, where title remains with the United States, but instead patented in fee to the Creek Nation. That is why this court in U.S. v. Creek Nation called it a former dependent Indian community. And under Venati, it clearly lost that status when the fee patent was dismantled. Now, assuming the land was a reservation, Congress stripped away all semblance of reservation status. Solemn asks us whether Congress's purpose was to divest the tribe of all its interest in the land. And here, statute after statute did precisely that. The Curtis Act ended tribal governance of the land. The allotment agreement divested the tribe of all its right, title, and interest. And even allotments were quickly stripped of federal superintendents. Everyone at the time read these statutes to mean the state had jurisdiction and the land was not a reservation.
Justice Alito?
Yes. Mr. Gershengorn has a section of his brief that's labeled "The Sky is Not Falling." And his argument is that you and the federal government are exaggerating the effect of this decision, that it won't have such a major impact either in the criminal or in the civil area. Is he right in that?
No, Justice Alito. So let me put some solid numbers on this. We have currently over 1,700 inmates whose crimes were committed in the former Indian Territory who identify as Native American. So the state presumptively would not have jurisdiction over those people and have to release them. And that is probably half the actual number because it doesn't include crimes committed against Indians, which the state would not have jurisdiction over. So we're talking here about potentially around over 3,000 inmates we may have to turn over. As far as future cases go, there were 32,000 felonies committed in the former Indian Territory, an area that is about 12% Native American. So only including crimes committed by Native Americans, that'd be 4,000 new felonies a year that the federal government would have to prosecute, including crimes where the Native American is the victim. You can take that to about 8,000. On the civil side, what happens is it creates precisely the differential legal treatment between non-Indians and Indians that Congress tried to abolish when it created the state of Oklahoma. So non-Indians would not be subject to presumptively to state zoning law, to dog law, as Justice Breyer mentioned, and that creates a disparity between Indians and non-Indians. So now non-Indian businesses are competing on an unequal playing field with Indian businesses. That's just one example. The Tulsa brief points out examples of on restricted allotments, how Indians are erecting billboards in residential neighborhoods or selling fireworks in them. But that's in the few areas, the 2% of land that remains restricted allotments. If the entire area is a reservation, then you're creating the two separate societies that Congress had sought to abolish when it passed the dozen statutes it did in creating Oklahoma.
Deputy General Needler.
Thank you, Mr. Chief Justice, and may it please the Court. In preparing the Indian Territory for statehood, Congress eliminated all the hallmarks of a reservation. Congress broke up the tribe's national domain and extinguished the tribe's interest in it. Congress likewise eliminated the tribe's territorial sovereignty over that area by abolishing tribal courts and prohibiting enforcement of tribal law in territorial courts. At the same time, Congress eliminated the distinct treatment of Indians under federal law. It instead subjected all persons in the territory, irrespective of race, to the same courts and body of law, largely incorporated from the state law of Arkansas. And Congress carried forward that framework for the new state. It directed that Oklahoma law would apply throughout the former Indian Territory and provided for the transfer of criminal and civil cases involving Indians and non-Indians alike to state court. Congress did not then radically change course and imposed a reservation-based jurisdictional regime throughout eastern Oklahoma upon statehood.
Mr. Needler, the Creek land was owned by the tribe in communal fee, unlike the situation on most reservations. Could you explain the consequence of that for the analysis in this case?
Yeah, I think it's significant, and I think it strongly supports this establishment here. The tribe had fee ownership as part of setting aside the territory for its nation to be undisturbed, and the treaties provided that no territory or state would be created there. So after all the non-Indians moved onto the territory, Congress concluded that was untenable, and it had to break up the nation, and that included both the fee and the sovereignty. And so when Congress provided for allotment, the tribe specifically ceded its interest in the land, conveyed its interest in the land to the individuals. And because the fee was the hallmark of their sovereignty, what made them separate, the tribe's own conveyance of the fee to individual members and extinguishment of all interest in it extinguished their sovereignty at the same time.
Justice Sotomayor?
Mr. Kneedler, I understood that statement was in light of the existing congressional disestablishment legislation that Congress subsequently changed and didn't go through with. But putting that aside, I haven't figured out whether you've accepted the Oklahoma's suggestion about the dependent Indian community exception or argument. Are you endorsing that argument?
No, not in terms. We're not. I mean, this court has discussed dependent Indian community separately, but some of what informs the state's argument we think is very important, as I said before. That
for disestablishment, but let's go back to, is there a consequence that we're unaware of? If we were to describe this creek land as dependent Indian community, what other things would we put in question? You're saying the things that inform that discussion inform your disestablishment. I understand your argument, but why aren't you endorsing the dependent Indian community argument?
Well, there could be other situations. I mean, for example, in Oklahoma, Congress has provided for various statutes to apply to tribes within their former reservations. And if these were regarded as dependent Indian communities, would statutes like that apply? Now, Congress still referred to them as former reservations. But one point that I think is that makes the dependent...
I hate to cut you off, but I do have one last question here, which is, what do we do with, if we say this reservation was disestablished, under what theory would we recognize Indian sovereignty over lands they kept? It was either disestablished or not. And why would all the complex laws that exist now giving the Indians the reservation, the casino rights and jurisdiction over lands that they own and all of those other things, what would be the basis of keeping all of that?
Well,
we would hold it was disenfranchised.
It's commonplace that when a reservation is disestablished, those parcels that remain as allotments or tribal trust land or of the sort remain Indian country. And so saying the reservation was disestablished, which has been the assumption for over 100 years, would not change anything on the ground, because and Oklahoma has always been understood that allotments are the fulcrum of tribal and individual activities.
Thank you, Mr. Kneedler. Justice Kagan?
Mr. Kneedler, I understand you want to support Oklahoma's position in this case, but just to follow up on Justice Sotomayor's questions about what dependent Indian communities were or were thought to be in 1935, do you think that those concepts were mutually exclusive, a reservation and a dependent Indian community?
No, I think there was a lot of overlap, and sort of the bottom. The court often described them as in general terms as land validly set apart for the use of Indians as such under the superintendents of the government, and that phrase appeared in Potawatomi in describing is there a difference between trust and reservations. So the same general concept is there, except for a reservation, as opposed to an allotment, for example. It's owned collectively, and so when the land is broken up, as it was here, particularly when it's fee land that is broken up, And when someone conveys their interest in fee to somebody else, they are conveying all of their interest in it. It's not like trust property on the typical reservation where when it's allotted, the United States retains an interest and therefore, on behalf of the tribe in some sense, retains an interest. When it's fee land, it is conveyed out of the tribe and the tribe loses all of its interest in the land. And that's particularly clear under this allotment agreement because it provides that the United States also extinguished, by approving the deeds, extinguished its interest in the land. And that interest was a reversionary interest for when the tribe was disappearing. And so by relinquishing the United States' interest in that land, at the same time it was conveyed to the individual allottee, it made it clear that the tribe as sovereign its sovereign authority over that land was being eliminated.
Mr. Gershengorn, you have 2 minutes for rebuttal.
Thank you, Mr. Chief Justice. A number of things. Justice Gorsuch, first, you're exactly right. This court may not be able to determine which party has the better reading of events on the ground 120 years ago, but it is surely well positioned to determine which party has a better reading of the text. And on that score, I submit this case is not close. Second, Justice Ginsburg, 2 points. With respect to fee title, that was meant to be an additional protection because everyone understood the imperfections in Indian title. The Creek didn't even get their patent until 1852, 20 years after the reservation was given. Elimination of fee title does not eliminate treaty promises. Those have to be disestablished through plain text. In addition, Justice Ginsburg, you're exactly right. The right title and interest language, which is the only text the other side can point to, conveys only proprietary interest, not sovereign interest, and so there is no textual transfer. There has been a lot of discussion this morning about irrespective of race. It is one quick point on that. When in the Enabling Act, in Section 13, what Congress put in place was the laws of the territory of Oklahoma, which did not have this supposedly magic language about irrespective of race. That suggests that Congress well understood that the arguments the SG and the Oklahoma are making on this score are made up for today. Fourth, there was a lot of discussion about whether there's a compromise available on criminal jurisdiction. There is not. Justice Alito listed a number of factors from Mr. Needler. One of the missing ones was the text. The text is very clear. I was amazed that Mr. Needler said there was no basis for believing that there was ignoring of the text. Nagansett said that is true. Secretary Udall's memo listed 7 states in which it were true. Finally, the numbers today are mind-boggling in back of the envelope. They don't appear in any of the briefs. The only fixed number is 178 petitions. That dwarfs Ramos. I understand the court's concerns about jurisdictional consequences, but there are no serious disagreements that these disputes are common in Indian countries.
The case is submitted.
And that was a little over half an hour excerpt from the McGirt versus Oklahoma case held May 11th before the United States Supreme Court. Now, as we said, it's far more complicated, and these were just some excerpts of a few chosen highlights. If you are interested in hearing the entire discussion, presentation before the Supreme Court, you want to go to Mvskoke Media's Facebook website, and you can get the entire case discussion. Now, there were some differences in the sound levels. This case was unusual in that it was a teleconference, sort of like, I believe it was Zoom. I don't know if it was Zoom. But anyway, the justices were all in different locations joining the program by teleconference. So you got some pauses in time as the time lag is dealt with. And certainly you found some differences in the voices of the justices themselves. Some were very strong, some were smaller. So we hope that you will bear with us there. As I said, if you're interested in hearing everything, then you want to go to the Mvskoke Media website. Now, going along with the presentation, there were some statements being made by, of course, the Mvskoke Creek Nation Principal Chief David Hill, and also the Oklahoma Attorney General Mike Hunter. They both had issued statements afterwards, and we've got these here, so we'll go ahead and share them in the time left we have. First of all, David Hill says, the Mvskoke Creek Nation has full faith and confidence in the Supreme Court process, adding, we feel tribal representation made our argument today with brevity and clarity. The decision is now in the hands of the court, and we will wait for that decision. Now, the decision, the date for an announcement has not been made, so it could be that it will be later this summer. It is the second time an appeal has elevated to the high courts arguing the existence of tribal jurisdictional bounds. And it's the second time the people most impacted by the question have waited and wondered. Now, in speaking for Oklahoma Attorney General Mike Hunter released his statement. On behalf of the state of Oklahoma, I wish to thank the U.S. Supreme Court justices for the time and attention given in this important case. I want to assure both tribal and non-tribal citizens my office will work with our tribal partners to uphold our long-standing mutually beneficial relationship to benefit all Oklahomans. Finally, I want to commend Oklahoma Solicitor General Mithun Mvskoke, who performed brilliantly under unprecedented circumstances. Now, the case now sitting at the Supreme Court is being heard through the lens of a public health epidemic. Justices and attorneys are navigating the strict procedures by teleconference like the McGirt case was, so that's the differences in the sound qualities there. The briefs were filed in the case were stacked with historical references of tribal law. Briefs were filed by the Mvskoke Creek Nation, Cherokee Nation, Choctaw Nation, and Chickasaw Nation, the state of Oklahoma, amicus curiae by Tom Cole, the National Indigenous Women's Resource Center, former States Attorneys Association, and the National Association of Criminal Defense Lawyers. Also, the National Congress of American Indians added its thoughts. But it was Jimsy McGirt's counsel, as you heard, Ian Gershengorn, the Mvskoke Nation's Riaz Kanji, which you probably did not hear, and Solicitor General Oklahoma City Mithun Mvskoke, and Deputy Solicitor General U.S. Department of Justice Edwin Needler on hand for appearances during those arguments. Now, Mvskoke media will continue to follow this case, such a landmark, such an important case for our people, and we will bring you what we can in terms of the highlights, the presentations in total, reactions from our own tribal administration and the state of Oklahoma, and then we'll finally get a Supreme Court decision, as we say, probably later this summer. Okay, what else can we got? Oh, the Mvskoke Creek Nation will begin returning to work next week on June 1st. This will be a phased return. You may not get all offices open at once, but those are being graduated back into the system, so to speak. Now, we will be observing general health hygiene practices, gloves, cleanliness, masks. All of that will be a part of what our future holds, so don't be too surprised if you come to the tribe looking for assistance there. All right, that's all I can do with it. We're going to get out of your way here and ask you to join us again next week for more Mvskoke Radio. Mado Mabo Hedget Awedgkis. You've been listening to Mvskoke Radio. Join us again next week for more local, tribal, and community news and updates. Mado.